Good afternoon and welcome to the November webinar presented by the Recruitment, Training and Support Center at the Federation for Children with Special Needs. My name is Paige Parisi and I am the Project Director at RTSC. Today's webinar, IDEA and Discipline, is being presented by Jennifer Honig. Jen graduated from Georgetown University Law Center and is now Senior Attorney at Mental Health Legal Advisors Committee. MHLAC is an independent state agency at the Massachusetts Supreme Judicial Court which focuses on institutional advocacy and community rights of persons with mental health issues. Our technical producer today is Renee Williams. If you are interested in learning more about the Federation, please go to our website at fcsn.org and explore all the different programs, including the Special Education Surrogate Parent Program, which sponsors these webinars. Our webinar today is being recorded and will be available on the RTSC website under the link Resources for Everyone. During the webinar, please type any questions you have in the toolbox and feel free to engage with others as appropriate. We will monitor the questions as they come in and, to the extent time allows, try to answer them before the end of the hour. If your question is not answered live, please send us an email and we will do our best to follow up with you. Jen?
Hi, so I'm Jen Honig. I work at Mental Health Legal Advisors Committee, and we are an agency that provides information and advice and some representation for people with disabilities, and we do have an intake process, so if you want to call with questions about clients or for professional advice, we offer that daily. So the last time I did this presentation, I did it in person, and I had a little picture that my daughter had drawn for me of Snoopy and Woodstock, and one of them was thinking, I guess, good grief. And that's how I felt when I was preparing for this presentation. The regulations and the statute are so complex in this area that every time I'd read them over and thought I'd understand them, I just would have this good grief response. So I hope I don't convey that response to you, but I think it is complicated. So we're going to focus mostly on the IDEA, and as you know, the IDEA is a federal law and it gives students with disabilities a right to a free, appropriate public education, which we call FAPE, in the least restrictive environment. And IDEA also provides protections for students who are subject to school discipline, and particularly when that discipline results in a change of placement, and we'll talk about what constitutes a change of placement. And additionally, IDEA requires schools to address behavioral issues of disabled students. So who is a child with a disability? So the definition in IDEA, it has two parts. First, there's the part of the definition that lays out the types of disabilities that are qualifying. For example, an intellectual disability or a specific learning disability. And the second part of the definition, though, you also have to be able to prove that because of the disability, the child needs special education and related services. So these are the children that we're talking about today, at least when we talk about the IDEA. So what about students with disabilities who haven't yet been found eligible for special education services? Do they fit into this process at all? So a child who hasn't yet been determined to be special ed eligible may be able to assert the protections that we're going to talk about today if the district had knowledge that the child was a child with a disability before the behavior that precipitated the disciplinary action. So before the incident, if the district had knowledge. So we need to look at now when is it that the district, that we could say that the district had knowledge of the student's disabilities. There's three sort of categories that of events that would qualify to prove that the district had knowledge. And the language is pretty specific. So the first is that the parent had expressed a concern in writing to a teacher or an administrator of the district that the student needs special education or related services. So it's important to note that that one's in writing. The second, these are all ors, so or the district is considered to have knowledge if the parent has requested an evaluation of the student for special ed needs, and that evaluation hasn't yet happened. And it doesn't say that that request has to be in writings, but hopefully the parent would have some documentation of that request, or the school would have it. The third possibility where the district would have knowledge is if a teacher or other school personnel had expressed a specific concern about a behavior, a pattern of behavior demonstrated by the student, and had conveyed that concern to either the director of special education or another supervisory personnel in the district. So it isn't necessarily enough if the teacher, talked to another teacher and mentioned the concern. They have to convey it to this higher level administrator. And there are some cases that are interesting before these cases that I cite are all before the Bureau of Special Ed Appeals, which is the entity in Massachusetts that hears appeals of special ed cases. And I've put the town that the case came out of, the school district, and the case number, and you can pretty much tell the year of the case by the case number. So 06 in this first example means the case was decided or heard, probably heard maybe, in 2006. Or filed in 2006. So in this example, a student was expelled for having illegal drugs, and even though the school personnel were sort of aware that the child had ADD, and the teachers had expressed some concerns around the student's level of attention, that wasn't enough. It didn't meet the probably the third bullet. The teachers hadn't conveyed those concerns. The school personnel weren't really aware of a request for an evaluation. It just wasn't enough. The only caveat to that case is in that case they had done a special ed eligibility determination and found the student ineligible at one point. And but as part of that denial, the school noted that the student should pursue the 504 eligibility process for services under Section 504, accommodations under that. And the school hadn't followed through on that, and the BSEA found that that was an error by the school. So in another case, the Monson case, again with illegal drugs and paraphernalia, in that case there was no record of behavior issues, but there was a request to do an eval for consent to do that eval was only signed on the very day of the expulsion hearing, and for that timing, the hearing officer decided was not early enough to trigger the school having knowledge. So you really have to be careful and keep records when you ask for, when you write concerns about a student to a teacher, and when you ask for a request for evaluation. Okay, so there are some exceptions, though, to when, even if the school is found to have knowledge that the student has a disability, there are some exceptions when the student would still not receive the protections that we're going to talk about here. And those three exceptions are if the parent doesn't allow the evaluation for special ed eligibility, if the parent ultimately refuses special ed services after a student is found eligible, or if a student was evaluated and found not eligible for special ed services. So now we're just going to back up and look broadly at how can a district discipline students with disabilities. So there is a specific provision in the statute and regulation that says that school personnel have to consider or may consider unique circumstances on a case-by-case basis in deciding whether to order a change of placement for a student who violates the code of conduct. So this is helpful because you could urge the school district to consider unique circumstances of the student with disabilities, and that they can't just sort of blanketly apply the rules of this code of conduct, but they need to look at the particular circumstances of the facts and the student's life and disability. So, and so the next question is, and we start getting into the days, which is complicated, but for how many days may a district exclude a student with disabilities without an obligation to provide FAPE? And we're just speaking about the IDEA now. So if the removal is for less than 10 consecutive days and the removals total 10 cumulative days or less in the school year, then the district does not have to provide the student with disability FAPE unless the district provides services for students without disabilities who are similarly removed. I think, though, in most circumstances, well, under IDEA, if we were just looking at IDEA, they wouldn't, but we'll talk later about Chapter 222, the new law in Massachusetts, which adds more rights, but this is just the obligation under IDEA. So what's an allowable removal of a student with a disability by a school district? So there's different kinds of removals. We sort of often just talk about suspension, but the removal could include suspension. It could include placement in another setting, or it could include an assignment to an interim alternative educational setting, which we abbreviate as IAES, for no longer than 10 consecutive days. In addition to that, the there's a DESE guidance, I guess it's a guidance, about discipline of SPED students, which says that in-house suspension can also be considered a removal, which is a change of placement. And what must occur when removal is for up to 10 consecutive days? So if the removal is for up to 10 days and it's not a change of placement, school personnel must consult with at least one of the student's teachers to determine FAPE services, and the services have to be sufficient to enable participation in the general education curriculum and progress towards IEP goals. It's participation in the curriculum. It's not, what exactly participation is sort of uncertain, and progress towards the goals, and again, how you progress towards the goals in that once you're removed might be a complicated question, but that is an obligation, and it's just to at least one teacher. So can the district do multiple removals in a school year? And yes, the school district can do multiple removals if each removal is no more than 10 consecutive school days, but only if those removals don't constitute a change of placement. It doesn't mean they can't do more, but then the rules will change. So we could keep going with multiple removals, no more than 10 consecutive days, until we get to the point where it's a change of placement. So what is a change of placement? So a change of placement could be two things. It could be removal for more than 10 consecutive days. That's the easy part. Or it could be a series of removals, each of which is less than 10 consecutive days, but that meets these other criteria. And then all three of these bullets have to be met. So it's more than 10 cumulative days. And it's that the behavior the incident that you're looking at now, the latest incident, is similar to the behavior in the previous incidents that led to this cumulative of more than 10 days. And then you can look at also additional factors, like the length of each removal, the total time of the removal, and the proximity of the removals to one another. So if you find a pattern by looking at these three variables, then you can also conclude that there's been a change of placement. And I think usually when it's more than 10 cumulative days, often it is a result of similar behaviors in the past, but usually schools will recognize that that's a change of placement. And it is the public agency that determines the change of placement, and they need to do it on a case-by-case basis applying these criteria. And the very decision about whether there's been a change of placement is subject to due process. You could appeal the school district's refusal to recognize a change of placement. I think maybe in most cases the school recognizes the change of placement and we move to the next set of rights. So what are the procedural rights when a school determines that removal constitutes a change of placement? So first of all, parents get, or these are just the most important, parents get notice of the decision to change the placement and of their procedural rights, and the sites are there to see what those rights are. And then the district holds a meeting, which is called a manifestation determination meeting, to review the decision to change the placement. And that's what we're going to talk about next, what this meeting is. So what's a manifestation determination? Again, it's a meeting that must be held after a decision by the school to change the placement of a student with a disability because the student violated the code of conduct. And at the meeting, the participants to the meeting review the incident that led to the most recent exclusion. So it's a meeting about the latest violation of the code of conduct and the discipline that's been proposed. And when must the meeting be held? So it's a little confusing. The rule is that the meeting has to be held within 10 school days of the decision to change the placement. What's confusing is sometimes schools hold it before the meeting, like the meeting with the principal to decide what the discipline is going to be, and sometimes they hold it after that meeting. And there's a case there, Holyoke case, which says that it can be before or after the exclusion hearing. It's sort of a long time frame, though, so hopefully it would not be 10 days after. But so parents have to receive notice of the manifestation determination at the same time they receive the notice of the decision to, I said suspend, but it doesn't have to be suspend, just of whatever the discipline is, the removal. And then the other cases I cite here are cases about what happens if the district doesn't hold the manifestation determination at all, and they're interesting. The Blue Hills case was a case where they didn't hold the manifestation determination meeting within the proper time, but they subsequently held it, and the student didn't challenge the outcome of it at that point, and so the BSEA said that that was okay. And then in the other case, the Salem case, it was clearer. There was just a total failure to hold the manifestation determination meeting, and in that case, the student had to be returned to school.
Jen, can I ask a clarifying question on the timing of a manifestation determination hearing? So IDEA says it must be held within 10 days of the decision to change the placement. Now, is there an exception, or is that just particular to this case when there was an exclusion hearing, this case in Holyoke? It doesn't sound...
No, that was the rule that was applied in that case. So it could be, it can be before, it still has to be within the 10 days, but it could be before or after the hearing, depending on where the hearing fell in those 10 days.
So the hearing, so just to clarify, we had a question come in, so just to clarify, the MD must be held within 10 days of the school's decision to change the placement.
Yeah,
and
that's
if there's an exclusion hearing, which it could be before or after.
Yes, and so that's only a footnote in that case.
222.
Yeah, and that's only a footnote in that case, so there wasn't that much discussion. It wasn't the center focus of the case. Okay, and who must attend the manifestation determination? So the statute and regs are pretty clear that the following types of people have to attend: the LEA, the parent, and then relevant members of the IEP team that the parent and the LEA identify as being important to attend. So it's not a meeting of the whole IEP team, but if the parent wanted certain members, they can request them and they should be there. You know, the parent might bring another person as well that's not a typical member of the IEP team, but those are the people that must attend. And what material should be reviewed at the manifestation determination? So this is also dictated by the statute and regs. They have to review all relevant information in the student's file, including the IEP, teacher observations, and relevant information provided by the parent. So that's information the parent provided that was in the file. I suppose the parent can bring more information, but they're talking about information in the file. So there was a case where there was, an Barnstable case where there was an evaluation that the school had received, but it wasn't something the school had focused on or done anything with, and that evaluation was relevant because it described the student's diagnosis and that stress caused loss of control. So it was completely relevant to the discussion, and the BSEA said, yes, you should have considered that, even though it wasn't sort of something the school had relied upon before. There's two questions which are asked at a manifestation determination meeting, and the answer to either of the questions will result in a conclusion that the conduct is a manifestation of the child's disability. So you could approach it two ways. First, most basically, was the student's conduct caused by or directly related to his or her disability? And the second one is, was the student's conduct the result of the school's failure to implement the IEP? So if you can go for the first one, and then if it's not working, you can argue the second one as well. I'm going to now talk about some cases around the first one, because that's sort of interesting. There's been cases about how close the connection has to be between the disability and the conduct. And the answer is the connection has to be fairly direct. But I think what's interesting in the way the case is split is that cases where a student's conduct appeared really to be just about their, like, losing control in the moment, and doing something, even if it was violent, something just so very impulsive, that the hearing officers seem more willing to see that as connected to disability as opposed to things which they saw as more deliberate. So, for example, in the first cases are cases where the conduct was not found related to the disability. There was a Situate case where a student pulled the principal's tie. You know, I guess in a threatening way, but still, it's not quite as serious as some of the other behaviors in these cases that we'll get to. But that the BSEA the hearing officer thought that action was deliberate and calculated, and really unrelated to the student's disability. Similarly, in a Westford case, the student was doing, he was writing names of people he didn't like on a list, and the hearing officer said that there was no evidence that he couldn't control his behavior when he was doing that, or that he couldn't understand the consequences of doing that, that wasn't something tied to his disability. And in Medford, the student was doing a whole bunch of different things, being in a prohibited area, profanity, fighting, smoking, and I guess didn't take off his hat or something. And the student tried to argue, the family tried to argue that that was related to his range of disabilities, executive functioning, ADHD, or a learning disability, but there was just no evidence in the record that showed a connection between the behaviors and those disabilities. So by contrast, in another case where the BSEA did find that conduct was related to disability, the Swansea case, the student was pretty threatening and was potentially acting dangerously towards the assistant principal, but the hearing officer said that behavior was related to the disability because the confrontation between the assistant principal and the student had sort of escalated, and the student and that kind of stress and agitation typically caused the student to lose the ability to self-regulate. So that was sort of a pattern that the student had demonstrated, and so even though the behavior was potentially dangerous, it was found to be related to disability. Okay, let's see. So what if the behavior is a manifestation of the student's disability? What does that get you? So if the conduct was due to a failure to implement the IEP, then the district has to remedy those deficiencies in the IEP, which is logical. The student stays in where they were. Then the district must, then these other principles, these other rights apply, whether it was under the first prong or the second prong. The district has to conduct or update a functional behavior assessment of the student, looking at how the student is doing in their school setting, and then implement or modify a behavior intervention plan for the student. And this could involve asking the school they may use their psychologist or bring in an expert to do that behavior assessment and the plan. And it's important to follow up at the meetings where the assessment is discussed and the plan is developed so that the parent can have input in those meetings to make sure it's a really good plan. And then the student has a right to return to the original academic setting unless the parent and LEA agree to change the placement, which they may, or special circumstances exist. So let's talk about special circumstances. So and then it's understood that there's not going to be an exclusion or discipline in the cases where the behavior is a manifestation of disability. So what are these special circumstances, though? So what happens today? Special circumstances exist when, and this is from IDEA, although the references to weapons and drugs also is mirrored in state statutes. So we just want to recall that this is about the IDEA, special circumstances. So if an incident involves possession of a weapon, possession or use of illegal drugs, and it could be at school or a school-sponsored event, or infliction of serious bodily injury upon a person while at school or a school function, and the definition of serious bodily injury is defined elsewhere in the statute, and I have the site there. That's, in any of those situations, special circumstances could exist, and then the district could move the student to an interim alternative educational setting for 45 days without a manifestation determination. Or they may have had the manifestation determination, but and the team determines the setting. So they'd have to reconvene and determine the setting, that the whole team. People who for whom special circumstances are found and are transferred in this way, they still have a right to educational services and assessments as if the conduct was found not to be a manifestation of disability. And we're going to get to that now. Those rights are described here. So what if the behavior is not a manifestation of the disability? So then the student can be disciplined in the same way and for the same duration as a non-disabled student. So they're treated like a non-disabled student. But after the discipline, the student returns to their regular placement. So what rights do they have as a special ed student when they're removed from their placement? The student has the right to FAPE, to enable participation in the gen ed curriculum and progress toward meeting the IEP goals. And that exists even if the student is placed in a different setting. And then also, when removed, the district must provide a functional behavior assessment and behavioral intervention services and modifications. So this is similar to what we talked about for students who before, but this is now for students where the behavior was not a manifestation of the disability and who are removed. So, the school has to do that because they don't want the behavior to recur. And it doesn't say when that would happen exactly, whether it happens while the student's still away or while back. Probably might not happen while the student's away, so it keeps going on when the student comes back. Okay, now we're going to turn to appealing manifestation determinations. So this would most likely happen when the conduct is found not to be related to the disability. But actually, the student or the district can appeal the results of a manifestation determination. The district might appeal it if they lose, if the student is found to conduct is related to the disability, and that district thinks that there is a potential for injury to another child or others if the student stays in the placement. More often, it's probably the student who's appealing, and they have you have within 2 years statute of limitations to appeal, but it's obviously the faster the better. The hearing officer can, well, at the BSEA, the cases can go to mediation or to hearing. If they go to hearing, the hearing officer can change the placement, either return the student to the original placement or order an interim alternative educational setting for not more than 45 days. So, for example, there was a Boston case with just an 8-year-old boy, and the BSEA found that he was posing a danger. He was punching and kicking, and he could be placed at McKinley, which was in another school within Boston, but a specialized school. Okay, so we're just going to quickly discuss who has the burden of persuasion at the BSEA and what the burden of persuasion is. The burden of persuasion is the responsibility of persuading the trier of fact, who's the hearing officer at the BSEA, that fact that their case is true, that the facts at issue is true. Sometimes people think of burden of persuasion as burden of proof, so the concepts get a little blurred, but it's this responsibility to persuade, basically, is the easiest way to think about it. And in general, the Supreme Court has ruled that the party seeking relief in an administrative hearing about the appropriateness of an IEP has the burden of persuasion. So that's the law for everyone. The BSEA reflected that in a Stoneham case. And then the BSEA spoke directly about the context of a manifestation determination appeal, that the parent has that burden of persuasion. So what that basically means is that if the parent doesn't present sufficient evidence to the hearing officer won't change the finding and won't find that the conduct is a manifestation of disability. So that means that really the parent has to put on the facts, has to present the documents, because they can't just rely on the school to present them, because the school doesn't want to change the decision. Okay, so now we're also going to talk about the standard of proof when seeking to show that conduct is due to disability. The standard of proof is how much evidence, how powerful and persuasive the evidence has to be that you put on. The standard of proof for these cases is a preponderance of the evidence, which is typical civil standard. And then another way of saying that is that the parent has to persuade the hearing officer that more likely than not the conduct was connected to disability. So the evidence has to lean to the side of the parent. Okay, so then we're going to shift a little now to another question. What if someone requests a special ed evaluation while the disciplinary action is pending? So you already got disciplined, but it triggered in the parent's mind that, oh, we should do a sped evaluation. So in that case, there's a provision to expedite the evaluation, and that's a good thing to press the school to do, although sometimes they'll just say they're doing as fast as they can, but there is a provision. And the student remains where the school placed them during that process. So if the student was suspended or expelled, the student remains there. The evaluation should proceed as best it can while the student is removed. It may be that it's helpful to finish the eval when the student comes back, and you can do more testing, like if you want to observe them in the classroom. So I just wanted to quickly touch on the rights of a student on a 504 plan. So say the student does not have special ed eligibility but does have a 504 plan. There are some overlap between the rights of the student on a 504 plan and IDA. The student can still assert a right to remain in the placement as they challenge the determination of discipline and argue that it is a manifestation of disability. The problem is that there's differences, that Section 504 just isn't as explicit as IDEA in how that process would play out. So for example, in the 504 statute, there's no list of specific questions to ask to decide whether the behavior was a manifestation of disability. And there's no list of who would attend the manifestation determination. And then later on, there's no provision for interim alternative placements. And then there's less protections for students involved with illegal drugs and alcohol. But the main thing is that there's not as much direction about how the manifestation determination would proceed. However, you could still rely on the IDA and say, well, we should use the same. You could argue that you should use the same questions and the same attendees as the IDA provides. Okay. I just want to mention here, sorry, this jumps again a little bit, but I think this is just good to mention that there are some additional rights around discipline that arise out of state regulation. So these are DESE regulations, and they apply to students in special ed schools, whether those schools are public or private. And there's sort of two sets of regulations that are relevant. One set is the regulations that are relevant when a school just wants to terminate services. And this sometimes happens when schools just fed up with the student and wants to send them back to the district. But there are a couple of protections in those cases that are worth mentioning. One is that there's no termination, even in emergency, unless the special ed school informs the public school district and the public school district responds by assuming responsibility for the student. In other words, they have to find another placement. And that can be delayed because the public school district can ask the special ed school to delay that termination for up to 2 weeks in order to convene a team meeting to discuss what would be an appropriate placement. So if a school is trying to terminate a student, it's a special ed school in Massachusetts, they should look to these regulations and ask and make sure the public school district is involved and is helping assert these rights for the student. There's some cases which I'm just going to skip over. And then there's another regulation, a DESE regulation, which is helpful which applies to public and private special ed schools. And this is one just about suspension. It provides an additional protection for students suspended for shorter periods of time. So this regulation says once a student is suspended for 3 consecutive school days or 5 non-consecutive school days in the school year, so this is much shorter than the IDEA, the school, the parents, and the school district shall explore together all possible program modifications within the school in an attempt to prevent total suspension from the program. So you're trying to avoid the termination that we just talked about. So that's another good protection. And just to note, these 2 regulations are in different sets of DESE regs. So these are in 18 and the other ones, going back, were in 28. Okay. Okay, one other source of a protection, which is good to think about when drafting IEPs, so earlier on in the process, and which may not fly in all school districts, but it's worth trying, is that the IEP team should discuss the school code of conduct and whether the student's required to follow the code, because a student with certain disabilities may not be able to understand the code or comply with the code or certain elements of the code, and that could be fleshed out in the IEP. And the Boston Public Schools has a form outlining how they would implement this concept, so it's a good reference. The last topic I'm going to cover is the new education discipline law in Massachusetts, which is called Chapter 222 of the Acts of 2013, and which has now been codified in various places in Massachusetts general laws, but I'm going to call it Chapter 222 here. I'm not talking about all parts of Chapter 222, just the ones that are most relevant to what we've already discussed. So the first topic I want to mention is Chapter 222 makes explicit the right to a hearing with the principal prior to exclusion for non-serious offenses. So when I say non-serious offenses, this doesn't cover felony charges and drug charges that are encompassed in other parts of Chapter 71. You'll notice that Chapter 222 here is codified in a new subsection of Chapter 71 called 37H and 3/4. So it has to be read in conjunction with the other parts of 37H. But for these students, a student is now going to have a right to a hearing. You know, before we were calling it a meeting, it's actually in the regulations, it's called a hearing. It's with the principal regarding the charges prior to the principal reaching a decision regarding suspension or expulsion or other discipline. And that's good. It's hearing with the student, but it's also hopefully with the parent. So the next bullet explains the principal shall ensure that the parent is included in the hearing unless the principal can document reasonable but unsuccessful efforts to include the parent. So the the regulations lay out exactly what those efforts have to be. And in most cases, hopefully, the principal will get in touch with the parent and have this hearing. And there isn't a time frame for this hearing in the regulation. The regulations also provide for appeal and to the superintendent. Those hearings have time frames laid out. These don't. But they would hopefully be fairly soon after the incident. The other thing I should mention is that there's exceptions in the right to a hearing for an emergency removal, which is when the principal thinks the student is just dangerous right then and there, and that can be, I think, for up to 2 days after the day of removal, and in-school suspension. So that's not considered, in this case, is not considered the same as an out-of-school suspension. So another important right of Chapter 222 is the right to make academic progress during exclusion. So this is in addition to the rights that we already discussed under IDEA. This is for all students. So a student suspended for 10 or fewer consecutive school days, whether they're in or out of school, have to be provided an opportunity to do certain things, and it's spelled out very explicitly. Some examples: earn credits, make up assignments, take tests, do papers, and other schoolwork as needed to make academic progress. So the key is that the student has to be able to do the things to make academic progress. Now, a student suspended or expelled for over 10 consecutive school days, again, whether in or out of school, shall also have opportunity to receive educational services and make academic progress. So, and again, so this compares to what's below there is the IDEA right to, for special ed kids, to enable participation in the gen ed curriculum and progress toward meeting IEP goals. But you can see that the language here is slightly different.
Yes, I just wanted to add, a lot of times the serious offenses that we talk about in both 222 and IDEA have exceptions, but in this case, this right to make academic progress for exclusions of more than 10 days is for any offense. So even the students who are charged with a felony, who have been caught with the drugs at school, or any of those quote-unquote serious offenses, they still have this right. So this covers any offense.
Yes, and that you can see that the place in the general laws where these rights are inserted is a different place than what we were talking about before, 71. This is now 76. So, and again, it covers everybody. Okay. Okay, and another good thing about Chapter 222 is that it explicitly says that for non-serious offenses, the school needs to take into consideration certain things when deciding the disciplinary consequence. So it requires school districts to take a step back and contemplate what consequences are appropriate for non-serious offenses. So, and it explicitly says that school officials shall exercise discretion, consider ways to re-engage students in the learning process, and avoid using expulsion until other remedies and consequences have been employed. So, for example, the little boy who just was waving his hand around, pretending to have a gun, he might avoid using, and then was suspended, you might avoid using, well, this is expulsion, but the same idea, exercise discretion, you might not jump first to suspension for a student like that. You might consider ways to re-engage the student in a learning process that talks about, appropriate behaviors. They were at lunch line, but the idea is that you have to be creative and avoid exclusion as a first resort. So, let's see. Okay, another impact of Chapter 223 is the considerations for young students. So, and I forget how old that student was, but when deciding on consequences for non-serious offenses for students that are in K through 3, there's an additional requirement that the principal has to notify the superintendent of an exclusion and describing the alleged misconduct and the reason for the exclusion. So it's just a notification requirement, but I think advocates were hoping that it would prompt some reflection by principals, maybe before imposing serious consequences on young students. And it's also a way to track how many of these exclusions are occurring. And that is all I have. And thank you to these folks.
Great. Thank you very much, Jen. It was not too much good grief in there, I thought. It is complicated, but I've heard you give this presentation before, and you do make it quite clear. We have some questions that I've been looking at as you've been going along, and I'll read them and I'll attempt to answer them, and you can jump in. Some of them I haven't had a chance to read. So one question we have is, how long does the school have to provide FAPE? I think this is came in when you were talking about in a manifestation determination hearing where it's not a manifestation of the discipline of the disability. So the question is, how long after that does the school have to provide FAPE, and does a tutor need to be in place within a specific time frame? And I would say that as far as the time frame is concerned, you know, it should be as soon as the removal begins. And whether or not a tutor needs to be in place, I think the specific services are decided upon by the IEP team.
Yes, I agree with that. I mean, tutor may well be appropriate, but
right. It's possible that that's a tutor,
yeah,
but that's not necessarily the case. Let's see. We have another question that came in earlier. I've had parents tell me that they are invited to a re-entry meeting, and then when they get there, the school tells them that it's a manifestation determination meeting. Does this violate prior written notice? How much notice do the schools have to provide for manifestation meetings? My understanding is that the notice of a manifestation determination is to be given on the same day as the decision to suspend, and the reg lays out a very specific procedural safeguard description that they're supposed to give to the parent with that notice. This issue about reentry meeting, manifestation determination, whether or not that violates the regulations, you know, I'm not sure about that. It sounds very case specific. I mean, if they gave the procedural safeguards notice as described in the regulation, you know, I think sometimes people do call these, well, I guess they wouldn't call this a reentry meeting.
Yeah, it's a little strange because re-entry meetings suggest that the exclusion has already happened, and hopefully, even though you have 10 days to have the manifestation determination meeting, if you have it after the whole period, then you can't step back. I mean, for the record, you could reflect that the exclusion was not a suspension, or but you've already, the students already spent the time. I think they should not be calling it a re-entry meeting, because it doesn't suggests to the parent the rights and what the nature of the discussion will be. I think that reentry meetings are problematic anyway, because they suggest that the parent has to come and the student has to come and have this meeting before they have a right to go back to school. And the student's right to go back to school is independent of whether that meeting is held. Sometimes it can, you know, it may be useful, but I don't think it's an obligation.
Good. That's a very good answer. Thank you. Let's see, I have a question about bullying. So how does this overlap with the anti-bullying law in Massachusetts? So if you have a child on an IEP with challenging behavior, and part of that is the child is exhibiting bullying, it's bullying other children. You know, how does that overlap with what we've been talking about? Well, I guess what's inferred in that is that the child is suspended for the bullying, and so if there is something in the IEP about challenging behavior, there should be something in there about bullying, because every IEP meeting should discuss bullying, So it would really depend on what's in the IEP about bullying for this student.
Right. I mean, I guess the best case scenario is that it was a problem that was pre-identified in the IEP and that there were services in place, and it may be an issue in the manifestation determination whether the school was actually providing those services to address the problem.
Right.
Or you could separately argue that, you know, even with services, that it is just a manifestation of the disability. That it, yeah, I think you do have to read the rights in the anti-bullying statute in conjunction and make sure you're having the team meetings that address bullying.
Right. Every team meeting should discuss the child's susceptibility to bullying. So then there's some questions that have come in that I haven't had a chance to look at, so let's just take a look at them. Does Chapter 222 apply to all students or just students with a disability or IEP? It actually applies to all students, general ed students, students on 504s, students on IEPs. It applies to every student in Massachusetts. So that's a good answer. So where can we see the questions, please? Oh, so there's should be a box on your screen where you can see the questions, right, as part of your setup for GoToWebinar. I'm not sure if the details how to do that. Sorry about that. Can't answer that question. I think you probably need to. I'm told you need to expand your screen to see that part of your screen. After a discipline hearing that happened after a manifestation meeting, the principal decided 30-day suspension for a small amount of marijuana in the backpack. Part of allowing the student to return to school after the 30 days, the family had to sign a contract. Certain behaviors must be followed, and random drug tests to be allowed back in school. So the parents have to agree to these terms.
Well, I wouldn't want to agree to random drug tests, certainly. I don't think there should be a contract in addition.
I feel like this was in a recent case that I just heard about, you know, at the special ed year in review about the where they had to sign a contract about random drug tests. So I don't want to answer this question without looking at that case. It was a private school. Certainly, I don't think they could do this at a public school. So Ginny, we'll get back to you with that answer. There's a very recent case on point there. Please advise this scenario. We will if we can. With a weapons offense, and the child is in the process of evaluation, but testing is not yet done because the child has been hospitalized. The school has already, the child needs a 45-day placement due to an emotional disability. That's why the child is in the hospital. Upon release from the hospital, the student comes to school on the first day and the weapon is found. A discipline hearing is done and a 45-day placement decided. So a manifestation determination is not needed since the placement was already decided. Well, should I repeat that? So the child was in the evaluation process, but then was hospitalized for a month. The school had already decided that they needed a 45-day placement from the hospital.
Before the weapon was found?
Yes. Then when the student came back, am I reading that correctly? The student comes to school the first day, yeah, and then the weapon is found. Well, it sounds like it's a new offense. Discipline hearing done and 45-day placement decided.
Well, I think if you just took the last part of it, that the weapon was found, if it's the possession of the weapon, then it's the special circumstances example. So look at the special circumstances slide and look at the regulation under there where it says the district can move the student to a setting for 45 days without a manifestation determination. Look at that regulation and see if that applies. I don't know whether the fact that they had already thought about a 45-day placement before that changes it, though. I think they still have the right because of the new offense. I'm not sure, though.
Do you know what slide that is? Is there? It's not numbered on your printout. Sorry.
It's.
Or what the regulation is.
1, 2, 3, 4, 5, 6. Yes, the regulation.
Yeah.
I think the regulation that's easier. It's
right.
34 CFR 300.530G.
Okay. All right. So we have time for one more. If the suspension is found, so this is a new question, a new scenario. If a suspension is found to not be an MD, and then the student is suspended again, does the clock reset for 10 days? Or do you need to do another MD after the next suspension, even if it's just a couple of days later?
I think you do another one.
Yes, you do.
Yeah.
You need to do another one. The clock is not reset. Also, what if the school team does not come to a consensus at a manifestation determination meeting?
Well, I think I've had that example where the school just decides it as their decision. It's not explicitly that the statute doesn't explicitly say there's consensus.
Right.
I think what happens in reality is the school will decide and then you need to appeal it. You need, yeah.
Okay. Great. If I've missed your question or if you have any additional questions, as I said in the beginning, please send us an email. And Jen, I know you put a lot of work into revising this with 222. We really appreciate all the effort and time you've put into this. Thank you very much.
You're welcome. Thanks for having me.
Thanks, everyone. We'll see you next month.